I will call the remote hearing of the Judiciary, Finance, and Civil Law Committee to order. We are meeting remotely under House Rule 10.01. I think we have a quorum, but we'll go ahead with the roll. Anna, please go ahead.
Chair Becker-Finn.
Present.
Vice Chair Moeller.
Present.
Representative Scott.
Here.
Representative Feist.
Present.
Representative Frazier.
Present.
Representative Grossel.
Present.
Representative Hurd.
Present.
Representative Hollins.
Present.
Representative Johnson.
Present.
Representative Liebling.
Present.
Representative Long.
Present.
Representative Mortensen.
Present.
Representative Novotny.
Body present.
Representative Farr.
Bar present.
Representative Robbins. Representative Fang.
Present.
And Representative Zhang.
Present.
All right. So first on the agenda, we'll move to the minutes of February 15th. Representative Scott, will you move the minutes of February 15th?
I certainly will, Madam Chair. So moved.
Thank you. Representative Scott moves the minutes of February 15th, 2022. Any discussion to the minutes? All right, seeing none, all those in favor, please say aye.
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 Opposed? All right, the minutes are approved from February 15th, 2022. Members, we've got this might be the most complicated bill we've had so far. Representatives Edelson and Albright. I will move, we'll get right to it because we've got a lot to cover today. So we'll get to House File 2725. I will move that House File 2725 be referred to the Public Safety and Criminal Justice Reform, Finance, and Policy Committee. Representative Edelson, I know that Representative Albright is joining you for the presentation of the bill, and I will turn it over to you guys.
Thank you, Madam Chair. And after I'm done, I'm going to pass it to my colleague, Representative Albright, to cover some of the details as well. Good morning, members. House File 2725 is the result of comprehensive work of the Competency Restoration Task Force, which was the result of legislation that was passed in 2019. An interim report was released in February of 2020, and this legislation is inclusive of the final recommendations of the task force. And everything that is included within is a consensus by the 25 members. The 25 members, I want to make sure that members here on this call know, included the sentencing guidelines, the Sheriff's Association, NAMI Minnesota, the State Court Administration, Direct Care and Treatment, DHS, the Board of Public Safety, County Attorneys, Hospital Association, Crime Victim Representative, as well as a reentry representative, and a Psychological Association. So just to make sure that everybody knows that we had everybody, all the stakeholders at the table when these decisions were being made. So, Madam Chair, House File 2725 does the following. It places provisions of Rule 20.01 in statute. It establishes a process for restoring a person to competency, including putting a time frame in for the completion of a competency examination report. It establishes guidelines for continued supervision for individuals found to be incompetent to stand trial. It also creates a forensic navigator position to work with defendants in the competency restoration process and develop a plan that will connect these defendants to appropriate services. It will also allow for judges to have additional discretion that currently they do not have. At this time, Madam Chair, I would like to yield my time to my colleague and my co-author, Representative Albright, who I've been working with this legislation on.
Go ahead, Representative Albright.
Thank you, Madam Chair. Members, over the past 5 years, the number of individuals who have been found incompetent to stand trial has steadily risen. The legislation and the work by the task force, along with Representative Edelson and myself, seeks to address what we call gap cases. This is when a person is found incompetent to stand trial and a civil commitment proceeding is triggered. However, under current law, if a person does not meet the commitment standard, it cannot be required to participate in treatment. If the charges are for misdemeanors, charges will be dismissed and many of these individuals will not receive help and may reoffend. If the charges are for gross misdemeanors or felonies, the charges will be suspended. However, if a person does not meet the standard for commitment, prosecutors can only file notice and wait for a defendant to be restored to competency. Again, with no mechanism to ensure that a person receives treatment or restoration, our legislation does then seek to ensure people get the care they need and are held accountable. And at the same time, this legislation will address the public safety concerns that have been raised by many of the stakeholders to this task force. Madam Chair, I would yield back to Representative Edelson.
Representative Edelson, go ahead.
Thank you, Madam Chair. So with this, Madam Chair and members, we do know that currently this bill will start to address an issue. Back in 2018, the Department of Human Services had ceased currently what they were offering at that time, which I will just say was probably inadequate as well. And so this is a beginning and a step forward to try to address the gap cases that we're seeing. There's been a lot of high profile cases that have been on the news. We do know that right now we are working with county attorneys. There's a few pieces that I think they would like to see for additional public safety. And we will be doing an amendment and working with them on that. And we'll be offering that in public safety. So at this time, Madam Chair, I would like to go to our first testifier.
All right, we do have several testifiers signed up. First on my list is Tim Carey. If you could unmute yourself, introduce yourself for the record, and then go ahead with your testimony.
Good morning. This says I cannot start my video. All right. Good morning. I'm Tim Carey. I'm an assistant Ramsey County attorney. I work in the commitments division and have a great deal of experience in trying to address some of the issues raised by the gap cases that were previously discussed. We note that in addition to the disconnect between the criminal rule and the commitment statute, there's a second gap, which is for folks who do meet the commitment criteria after a finding of incompetence. There's not sufficient support in the community once they've been provisionally discharged from the hospital at this time. The beauty of the work with the task force is that it contemplates a complete overhaul and a large scale investment into the mental health infrastructure in the state, which has been lacking for some time. So it has been it's a great success of the task force. I believe that the entire continuum of care is represented, from the forensic navigators previously referenced to very careful case planning when people are embroiled in the criminal court process, in addition to having a mental illness or substance use disorder. The County Attorneys Association would simply highlight the need to keep some of these cases alive in the criminal court process longer than the task force bill contemplates. I can provide some of the statutory subdivisions if that's something that that you'd like to hear about. But ultimately, we need more time for people to recompensate and stabilize in the community. And we believe that by extending the period of time that the criminal case can remain open, we have a better chance of achieving those public safety goals in addition to treatment goals.
Right. Thank you for your testimony. And we don't have to get into statutory citations right now, but I'm sure if members have questions, if you can hang around, that might be helpful. Next on the list, we have Sue Abderholden. If you could unmute yourself, introduce yourself for the record, and then go ahead with your testimony.
Thank you, Madam Chair. Members, Sue Abderholden, Executive Director of NAMI Minnesota, and also Chair of the Competency Restoration Task Force. As was mentioned in 2019, the legislature created the Community Competency Restoration Task Force And our charge was to identify and analyze resources for defendants who have been found incompetent to stand trial, research how other states address this issue, and develop recommendations to address the problems. And really it was created because we saw really a huge increase in the number of people deemed incompetent to stand trial and the number of people going from jail into Anoka Metro Regional Treatment Center. Those also increased greatly, and that left few beds for people coming from inpatient psychiatric units. I do want to note that this is an issue not just in Minnesota, but across the country. I had the privilege of being on a national task force to actually look at this issue. And frankly, other states are also trying to figure out, what do we do? We did try to figure out why there was an increased number. And honestly, we couldn't come up with a single answer. Certainly it could be because there's greater awareness around mental illnesses. Also was discussion around the increased use of meth and other illicit drugs, but there was no one solution. I think the task force worked well because we really had a wide variety of people at the table, and we took public input at our meetings. And I think it was critical that we had public defenders, county attorneys, forensic psychologists and examiners, DHS, especially the Drug Care and Treatment, Department of Corrections, Minnesota counties and social service departments, the mental health providers, victims, people with lived experience, and advocates. And what we found is that the current system assumes that all people found incompetent need the most acute level of care and that most people will be committed, and both are simply untrue. The Minnesota Judicial Branch provided data that between 2016 and 2018, 3,214 people were found incompetent, 1,471 for felony charges, 1,256 for misdemeanors. Of the people with felony charges, only 46% were actually committed. While misdemeanors, as was mentioned, are dismissed if someone is found incompetent, the court can still refer the defendant for civil commitment, but only 36% of misdemeanor defendants were actually committed. On top of these gap cases, the task force found other reasons to create a better process for competency. Judicial branch spending rose 40% from 2014 to 2018, topping off at over $6 million spent in 2018 on forensic exams alone. Our research found that only about half of the time judges were ordering mental illness defense exams concurrently with competency exams. But a defendant should be asserting a defense if their competency is in question, making these mental illness or Rule 2002 exams inappropriate. After 2 years of work, the task force published an interim and final report with recommendations. The task force recommends a process for directing defendants to competency restoration services, developing a continuum of where and how services are provided and to which populations, addressing defendants who are not restorable and those who do not meet commitment criteria, and creating a competency curriculum that can be used across settings. House File 2725 was drafted with continued engagement with task force members and stakeholders to implement the recommendations of the task force. We worked by consensus, which means basically that no one is happy and few are adamantly opposed. We do recognize that this bill is broad and that there are further amendments that are needed. But again, I think it's important to reach consensus among all the stakeholders. Broadly, the bill does three things. It creates a process in statute when a person is found incompetent to stand trial, updating and improving the current process in Rule 20 of the Rules of Criminal Procedure. We tried to address what we call the gap cases, where people don't meet the civil commitment criteria, but need treatment and supports. These individuals are often frequent utilizers of both, the jails and, frankly, emergency rooms, because we never address the underlying problems. We create forensic navigator positions within the judicial system to really help people in the competency process to make sure they show up for exams, that they come to hearings, that they get connected to services and treatment, and they will help prepare plans before charges can be dismissed. Forensic navigators also help the courts carry out the work of helping people become competent again. Finally, the bill creates procedures and standards for judges to send people to community competency restoration programs, depending on the level of care that they need and public safety, instead of relying on civil commitment that has created gaps in the system. The bill includes, creating these forensic navigators and competency restoration programs in the community. There's another bill that was actually heard yesterday to create locked residential treatment facilities around the state. I think the big issue truly is, we do need funding to carry this out, but we are already spending funding that frankly is leading to ineffective results. It's very inefficient. So by filling the gaps in the system, we will actually, in some ways, I know you hear this a lot, but we'll save money in terms of the courts, the counties, and the state, but we'll be putting money into things that we think will actually have a larger impact, both on individuals who frankly are never getting the treatment that they need, but also on our communities. Thank you for the opportunity. I will mention that Elliot Ty from my staff, who really wrote the report and did a lot of the research, is also here if there are further questions. Thank you.
Thank you for your testimony. Next on the list, I have Bob Small. If you could introduce yourself for the record and then go ahead with your testimony.
Thank you, Madam Chair. My name is Robert Small. I'm the Executive Director for the County Attorneys Association. Thank you and members of the committee for allowing us to talk about this very, very important bill. I also wanted to thank Representatives Edelson and Albright for their patience and for the opportunity for the county attorneys to express our concerns with this bill. And we look forward to working with others to come to some agreement that is in the best interest of everybody as well as best interest of public safety. So for the purposes of background, our association has been working on this issue for a long time. In 2017, we put together a special subcommittee of assistant county attorneys who deal with this issue every day and who see the impact of the absence of a legislative fix on public safety. And we came up with a bill in 2017 that was introduced and authored by Representative Edelson. That was House File 2904. That was in 2019, and then the task force was implemented by the legislature in 2019, and a lot of what was in our bill in 2904 was incorporated in the current bill. So I wanted the members of the committee to know that we think that the bill has a lot of very, very good and important provisions, but we think that it could be tweaked to better serve public safety. Assistant Ramsey County Attorney Tim Carey has already mentioned that, and I just wanted the committee to know that our association stands behind what Tim has talked about. And I'll stand for any questions, but thank you very much for hearing us out.
Thank you for your testimony. Next on the list, I have Commissioner Terrell Clark. Please introduce yourself for the record and then go ahead with your testimony.
Good morning, Madam Chair and members. Thank you for this opportunity to speak before you today. My name is Terrell Clark. I'm Stearns County Commissioner. I'm a board member of the Association of Minnesota Counties and a member of the Competency Restoration Task Force, along with a couple of our MAXIM members to represent counties. I do want to piggyback off of a few things, particularly that Sue Abderholden referred to. While our charge was to specifically focus on competency restoration services, we also broadly focused and acknowledged the significant need for prevention, stabilization, supportive housing resources, including for those for whom competency is unlikely to ever be attainable. Much of these efforts and the needed resources occurs outside the court system, but impacts what ends up eventually coming before our courts, including before and after proceedings. So for example, I'm really proud of the work that we've done in Stearns County with our community action team that has broad representatives across our community, being able to bring down some of the frequent flyer cases that were referred to and make a difference in saving money, safety in our communities, and making a difference in individual rights. But there are still significant gaps. To be successful even in this initiative, the broader issues must also be addressed, including those outside of the purview of this bill. The Association of Minnesota Counties supports the effort to reform the way Minnesota provides competency restoration services. We'd like to thank Reps Edelson and Albright for your work, and to fellow members of the Competency Restoration Task Force for truly the deep dive into this issue for over 2 years. There is an immediate need to reform competency restoration and to enact legislation that creates a path forward for Minnesota. When the Department of Human Services announced in 2018 it would discontinue the competency restoration services for certain individuals, it created a serious gap in services in our state. Competency restoration services have long been provided by the state, and currently there's no broad infrastructure, statutory directive, or regulatory framework in place to provide these services by other entities. The Association of Minnesota Counties believes that this bill is a good step at identifying a solution, including navigators through the judicial system, and that we need to have work continued and want to be part of that work before final passage of this bill. We have concerns about the language related to pretrial supervision for those found incompetent to stand trial. And while it acknowledges we don't have a process or resources for those found unlikely to attain competency in the reasonably foreseeable future. An example would be some people with significant brain injuries, for example. Many counties don't have the resources to provide pretrial services. The bill directs the court to determine whether defendant needs pretrial supervision and gives the authority to place that person on pretrial supervision with a willing entity. Currently, and this goes back to what Ms. Abderholden said, we weren't able to come up with great fixes for everything, but the bill currently doesn't have the funding or appear to have funding for supervision, which could last up to 3 years for felony files. So as this bill moves forward, it's important we ensure the components of this program are adequately funded. A lack of sufficient state funding or proper implementation planning could exacerbate existing inequities in access to services across the state. Currently, community competency restoration programs are not available across the state, and we know appropriate investment is needed to develop and sustain a successful service. We're committed to continuing to work with the author and other stakeholders on the bill to ensure the program is successful and meaningful when the legislation is passed. Thank you, Madam Chair and members.
Thank you, Commissioner Clark. I don't have anyone else on the list to testify, but I have a lengthy list of people available for member questions if we have them. So with that, we will move on to member discussion. Members, now would be the time to raise your hand. One question I have that, not being able to go back and watch all of the meetings of the task force, I'm really interested in the forensic navigator position, but it's not clear to me from the bill what kind of background you would expect those people to have, or would they be folks coming from like a therapist background? Would they be people coming from more of a courts background? So wondering, Representative Edelson, if you can speak to how you guys imagine what kind of workers would fill that role.
Thank you, Madam Chair. And I will send it to NAMI to articulate or maybe elaborate a little bit more on this. But my understanding is the courts will be meeting to do some planning around what this person would look like. I do believe that they need to have a background, from our legislation, that they're going to have a background in mental health, but also to also have a background with understanding the court system, because the navigator will actually live within the court system versus Department of Human Services. So Ms. Abderholden, do you want to expand?
Ms. Abderholden.
Thank you, Madam Chair. So they won't be mental health professionals because they're not treating someone, right? In some ways, they're kind of more diverse case managers, but being in the court system, it could actually be a peer specialist. So someone who can really connect to someone who is, their mental illness is kind of, has caused them to be incompetent. It could be a mental health practitioner, but I just want to make it clear, it doesn't have to be a mental health professional because they aren't providing active treatment to that person. They're really kind of following and engaging them in this entire process and making sure that they don't fall through the cracks.
Okay, thank you. So would this be someone with a bachelor's degree in psychology? That's so I'm trying to get at And we had the bill regarding intensive residential treatment services this week in behavioral health policy. And so for folks who are unfamiliar with that, that's sort of a facility in between, being in, locked up in a hospital and being back out in the community. And just wondering, I feel like we're not connecting the dots as far as who would fill these roles when we already don't have enough staff in the mental health system. So that's what I'm trying to get my head around, further out. Do we need to be looking at creating programs? Do we need to be looking at training, all those kinds of things? And it looks like Representative Albright, if you want to weigh in, that'd be great.
Thank you, Madam Chair. This is a question that has been posed on a regular basis. And while I qualify my answer to say it's a fluid conversation, I think that you hit at a nexus in terms of we really are creating a new occupation with this legislation, because on the one hand, you really do want to identify an understanding and expertise in the mental health and the behavioral health sciences. But it's also important to note that these individuals would also really come out of an understanding from the judicial and the law enforcement perspective as well. Because much like a probation officer, if you will, it is the understanding of this legislation that there is a clerk of the court attitude surrounding these forensic navigators. Because one of the points to be really alleviated by this legislation is to make sure that those that are going into treatment that are found to be incompetent, that they don't slip through the cracks any longer, that there is some accountability for seeking and fulfilling the obligations of the court order through an analysis, through interviews, to complete their court ordered process of potential rehabilitation or competency. So I think it's important to note that this isn't just about their mental health, but it is also really respectful and understanding of what the court system has instructed them to complete, to be held accountable for the offenses and the charges that have been brought against them.
Yeah, thank you.
Just one point on that, and I think with that, whether it's a 2-year degree in law enforcement or a bachelor's degree in behavioral health, I think it is a hybrid that the stakeholders will come together and really achieve what that curriculum looks like. And because of that curriculum, I think you'll find the types of individuals that will seek after that occupation.
Yeah, thank you. I was trying to get my head around how big this number is going to be. And I think, the training and what you're paying these folks to work as the forensic navigators is likely going to dictate that piece of it. So thank you for that background. We'll go to Representative Scott.
Thank you, Madam Chair. This is a bill with a lot of moving parts. And I think we could spend the entire morning on this bill asking questions and trying to get to the bottom of this issue. I work with Representative Albright over the interim a little bit on this issue because the stories are tragic, both for the victims and for the people that are committing the offenses. It's because they're not getting the help that they need. And I think some of this goes back to DHS's decision to not have the role of restoring these people. And, they say there's nothing in statute to require them to do that, but I see the complexity of this bill, and I'm wondering if at least in the interim until we get a solution, because it's going to be expensive, it's going to be complicated. We don't even have forensic navigators as a profession right now. If one of the solutions and one of the first pieces might be restoring that responsibility to DHS and put it in statute and say, you have to follow up on these people. Because what was happening as I was meeting with county people, county attorneys and stuff, was that DHS said, we're not going to track these people anymore. It's turned over to the county, and there's just again gap where these people no one's following up on them. They're not getting the help that they need, and they're oftentimes, as we see in these news reports, a danger to society. So to me, that is one of the first steps. And And it seems like, and I was glad to hear Ms. Abderholden say that there was a bill that was heard to, build more healthcare or mental health facilities. We obviously need that because one of the troubling parts of this bill is if they can't find a bed for these people, they're back out. They have to be released. The case is dismissed. And that is not a good way to handle the public safety aspect of this. And so my other broader concern is that we're turning the courts into a social service agency when, to me, this is traditionally being handled by DHS. They're the people that have the expertise in dealing with mental health and these issues. And so I'm just wondering, I don't know who this question would be, directed to, but what is DHS's role, if anything, in this bill to help with this issue? And I don't know if that's for Ms. Abderholden or one of the bill's authors.
Well, I see Representative Albright has his hand up, so I guess we'll give Representative Albright, we'll give you a shot at that one.
Thank you, Madam Chair, and Lead Scott. We actually do have a bill that addresses the issue in the interim, because your points are well taken in terms of the implementation of this bill. It is not going to be quick, nor is it going to be simple. And so we readily identify that there needs to be something to stand in the gap, no pun intended, while we finalize the implementation of the larger bill. To the extent of cost, and I come from an investment background, and when you take a look at, as Ms. Abderholden said, what we are spending right now for services, whether they be through the court system or whether they be through DHS, it is uncoordinated. And that goes to your final point, is when we have had conversations with DHS, and this is not to negate the efforts that they make, but no one knows what is going on. There is no coordination. There is no understanding in terms of the process by which these individuals must comply and follow through. So the two parts that our bill addresses, one, it quickly identifies who is responsible. Now, the suggestion that the court system becomes a kind of a health and human services subdivision, I would take respectfully exception with that, because I think the judicial courts actually are the point from which these individuals are then directed to seek treatment, to seek services from DHS. So it's actually the beginning of that journey for that individual, and it's directing DHS to comply with the court order, as opposed to those individuals, sadly, being lost within DHS for the various services and departments that they have. It isn't an easy program, and as the chair readily identified in her opening remarks, this is not something that fixes all the circumstances that are presented, but it is a very good foundational start to what many have said is a really tragic situation that we need to address. Will it come with costs? Absolutely. But the near-term costs versus the long-term effects in terms of community safety, public safety, as well as the confidence of the citizens in their judicial system, as well as DHS, that comes at a cost too. And so we're looking to make sure that these people come out of the shadows and become productive citizens of the society that we all want to participate in, but that they're also held accountable for the offenses that they're charged.
Yeah, thank you. Representative Edelson, and then we do have quite a few other people who want to weigh in addition to letting Representative Scott get a second chance at it. So Representative Edelson.
Thank you. And I agree with everything my co-author just said. I just want to make sure that we go back to Representative Scott's point. In 2018, when the Department of Human services decided that they were going to discontinue the plans that they currently had, those were insufficient at the time too. And I think that's what across the states, across the US that we're seeing is it needs to be this partnership of public and private because we don't have enough resources. So we have the demand there. So we're going to have to look and see how do we build that system. And so this will take you are pointing out exactly what is right. And you've got it. It is a messy process that we are trying to build a system that really hasn't quite been there yet. So I would like to just have Ms. Abderholden just address this as well.
Ms. Abderholden.
Thank you, Madam Chair. Representative Scott. So one of the things to remember is kind of how our system currently works. So, the state operated services, they're supposed to serve basically a small percentage of people who are committed to them and need that level of care. And that level of care is an important piece of it. Most of the people who have been deemed incompetent are never committed. And so that's that huge group of people that never even get into DHS. And the competency piece is really the courts, but the treatment piece is really DHS. And one of the problems that happens is in the way that we have our state set up is the counties are actually the mental health authority. So someone may get committed to the Department of Human Services when they no longer need that level of care, because this is about level of care, not prison, not jail. Then they are sent back through the commitment process to the county. And technically the county with their commitment case managers are supposed to be the ones, really kind of following that person into the community. So we have a lot of different actors at the table, which also makes this more difficult. But I think it's important to remember that it's levels of care that we're really talking about and how people move through that, and then making sure that they don't get lost in that process.
Thank you. A follow-up, Representative Scott.
Oh, so many. Thank you, Madam Chair. But
and Representative Scott, I will say, since we don't have the fiscal note and the details are still being worked out, it is my intention that this would come back to us after they've sort of vetted the public safety aspects of the bill. So I don't think this is the last time we'll be discussing these issues. Representative Scott.
Thank you, Madam Chair. And I'm glad to hear that it would be coming back, because that was one of my other issues was this is going to be super expensive. And when we do those pre-session, what are your priorities with the local media? I say this is one of my priorities is we need to get our head around these gap cases. And I've said publicly, it's going to be very expensive to do. There's no question about it. So, but this is money that we have to spend because it's an overlap of public safety and mental health. It has to be addressed. And so I guess I will end my comments there. I do have a lot of other questions, but I'm glad that it would be coming back to our committee. I think it's going to be very expensive. And I would like at that time, if not before, to hear from the courts on what their take or concerns might be on how this would work for them. Thank you, Madam Chair.
Yeah, thank you. Representative Herr.
Thank you, Madam Chair. Sorry, I'm trying to work off two devices because I'm having issues with volume here. Chair Becker-Finn, I'd just like to ask Representative Edelson just a quick question, because I know that there is a lot to be worked out within this bill yet, and I just want to thank her for bringing it forward. I just wanted to ask that since we had heard that multiple states were also facing the same issue, could she maybe just give us an idea of what other states have done to sort of address this situation, or what are the ways in which they're proceeding with this issue?
Representative Edelson.
Thank you, Madam Chair. Ms. Abderholden would be the best one to elaborate on this. And I think it is actually great for committee members to hear more about this. So thank you, Representative Herr, for asking that.
Ms. Abderholden.
Thank you, Madam Chair, Representative Herr. No one has quite figured it out, and several states have actually have been sued and under court orders because people have been languishing in the jails while they've been deemed incompetent and not getting services. Colorado was trying out forensic navigators. That's where we got the idea. Because I meet with my counterparts across the country, there are several bills in legislatures right now looking at how we address this. And I'd be happy to share. The national report is somewhat helpful. A lot of them talked about the need to develop your community mental health services and to make sure that you're not just committing people to state hospitals if that's not the level of care that they need, and really trying to separate out commitment from competency restoration. But no one has that great magic wand that we can just take right now. Everyone's really trying to figure this out.
Follow-up, Representative Herr.
No, just a quick question, just a quick comment, Chair Becker-Finn. I just wanted to say that this is a complex situation. This bill came before me just to actually take a look at it and understand it better earlier on, and that it is the details will need to be worked out, and we will have to put funding towards this if we want to do a good job of addressing this issue, and that we could be a leader in this. I just wanted to thank Representative Edelson and Representative Albright for bringing this forward.
Yeah, thank you. And I think it sort of to Representative Albright's comments as well, we need to make investments in things, it does save us money long-term, the same way that investing in housing and taking care of people in other ways, can have benefits in that way. So I think that is an important point, Representative Herr. Representative Johnson.
Chair Becker-Finn, members, I do as well have many concerns on this bill. I know why we need to look at this. It's a serious issue. I'm just wondering if when this bill was being put together, if they proposed, or if somebody from the courts is here that could give us some of their concerns on this bill. And I know the cost is going to be huge on it. Because I just want to make sure that the courts were involved in this, because it deals with the courts to make sure that statutory, not just statutory, constitutionally, they're allowed to do some of the things in this bill.
I can actually handle that one, Representative Johnson. I know that the courts were on the task force, and sort of to Ms. Abderholden's point that this is a consensus bill. So I assume, I guess you can confirm for me, Representative Edelson, but if the courts were on the task force and this is the consensus bill, I'd assume that this has their blessing. Representative Edelson.
You are correct, Chair, but we will make sure, Representative Johnson, we can have a member from the courts testify in public safety, so that members do hear the court's perspective on this.
Yeah, and as I said, I mean, they didn't sign up to testify, but because this will be something that comes out of the court budget, and it is, purely in the judiciary finance realm, we can address that when we have a better idea of what that fiscal note looks like. Any follow-up, Representative Johnson?
Yeah, Chair Becker-Finn, one of the concerns I have on this bill is the way it's written out. It's just people are getting lost in the system already, and now we're putting more steps into it. In some of the meetings I've had dealing with this issue, talking to some of those at the county level, they were never notified when somebody was coming off the state to the county level that they were responsible. I think we need to take a deeper dive into what happened, why these people were gapped when they're sent back from the state to the county. And on these situations where it's the state imposing this, dealing with the courts, I think the state should be 100% responsible, and it shouldn't go to the counties. The counties have enough on their hands already with the issues that they're dealing with besides the court system, and the court system is part of the state. So I think that's where some of the gap came from, is because the counties were never notified that these people were coming back and they were responsible for them. So it's, and as you had, Chair Becker-Finn stated, in 2018, DHS on their own changed how they were doing things, not statutorily, they did it themselves. And that created part of this problem. We also have an issue of a lot of bed space that have been shut down. We don't have facilities for these. So I think we need to take a deeper look, and maybe not this big, huge thing that we're putting together with other bills, as we're spoken, dealing with the bed, new facilities. But I think we need to look at how those just through this court system are handled, and the state should be responsible for them and not put it on the back of the county taxpayers. Because a lot of these times, these people actually don't even live in the communities that the offense occurred in. But now if they go back living with mom and dad 3 counties away, the people in that county is going to have to deal with it. And they weren't even involved in that. So we have to so I think we have, instead of putting this on the backs of the counties by turning them back over to the county, the state needs to be 100% responsible for this.
I hope you will support the funding that would allow the state to do that. Any comment, Representative Edelson?
Madam Chair, I was just going to say, the task force really, this is not just, this issue cannot just lie in the hands of one agency. It really is the entire states. It should lie in all of our backs to do something. And so I think it's taking this comprehensive approach, which is why we have the task force, because we after DHS stopped at least the services they were giving, which were inadequate at that point, we realized that we need to begin a new process. And that new process we're trying to carve out, which I think members can see is very complicated. So thank you, Representative Johnson, though I definitely have written down some notes and would love to connect with you after the committee if you're interested.
All right, final follow-up, Representative Johnson.
Just that I don't want to put this funding that it's going to cost. And I have a feeling with the other bill that they talked about, we're looking at probably $1 to $1.5 billion for this program over a biennium. Just looking at the bill and what I'm seeing, I would be surprised if it's less than that with the 2 bills combined. So this is a serious issue. I don't want to put this money on the property taxpayer of the county. They get their funding at the county level from the property taxes. This is a state issue and not a county issue. So I think the state needs to find a way to bear the entire burden of this system, because it's those in the criminal justice, going through the criminal justice system, which is the state's responsibility, especially when you get to felony level offenses.
Representative Grossell.
Thank you, Madam Chair. Don't need to look at just the top of my head. I guess I want to see this old mug, but I had just had a couple of short questions. Is there one tracking in the Senate, or is the Senate planning to hear this bill?
Representative Edelson, I don't think she can speak for the Senate, but I'm sure she can speak to what she knows. Representative Edelson.
Yes, this will be moving in the Senate as well. And we have a Republican author. I cannot remember. Somebody help me out here? I have too many bills. Sorry.
Ms. Abderholden.
Thank you, Madam Chair.
Senator
Representative Edelson. It's Senator Sundin. And we did meet with Senator Limmer this week, who is kind of interested in the concept and I think very interested in hearing the bill.
Representative Grossell.
Thank you. And thank you, Madam Chair. And thank you for that answer. I guess I didn't, maybe I missed it, but did the courts comment on this at all? The language, did they approve this language? Because I heard that they were involved in the initial task force, but what were their comments? What did they have to say about this?
Representative Edelson.
I was going to say, Madam Chair, I would call on the chair of the task force, which was Sue Abderholden, could maybe elaborate a little bit for members.
Yeah, Ms. Abderholden, and I will say again that the courts were on the task force, were involved in this, and this is the consensus bill. Ms. Abderholden.
Madam Chair, Representative Grossell, they did send in some comments, and we met virtually, especially during this last year, and one of the judges was present at the meetings and suggested changes. Now, once we kind of got the bill so that we could get it into the revisor's office in December, you know, it isn't like we sent it out and said, everyone send in and vote yes, but everyone was told, this is your chance. If you have other changes that you want to make, you know, please send them forward. And, you know, again, we did reach by consensus. Clearly, once things come in writing, bills get heard, people start looking at it more carefully and recognize, especially since it's such a large bill, that there may still be changes needed, which of course we are totally open to. We know this is not, having been around a long time, your first big bill is not perfect.
Representative Albright, any follow-up to Representative Grossel's question?
Yes, and I appreciate the question. And one of the things that I think is notable about the process here is the stakeholders are not antagonistic towards one another on this issue. I think one of the points that is said is it is a very large, dare I say, grand collaboration between a number of people that have grave concerns about the current situation and want to make it better. And so to that extent, I can assure you that this bill is, I don't want to say work in process, but that collaboration continues. And I would expect that you'll see some modifications in the form of a couple of amendments at our next committee stop to address some of the issues that you've heard in this committee hearing. But I just want to make sure that for the folks watching this committee hearing, as well as for the members on both sides of the table, if you will, that this is a collaboration. It is not antagonistic towards the efforts moving the bill towards a culmination where everyone agrees with the tenets and how we can make this process better for the state of Minnesota.
Follow-up, Representative Grossel.
Not really, Madam Chair. I mean, this is a problem that has been, oh Jesus, needed to be worked on for years. We need to find a place for these people to get the help that they need, and sitting in a cell is not the place for them. You know, so I do appreciate our authors, both of them, Representative Albright and Edelson, for bringing this forward. You know, and I appreciate their willingness to keep working on this, to try to fine-tune it to make it the best thing possible. I guess, you know, just one more question for either one of them. Would the money be better spent on getting some healthcare facilities moving, getting those things up and running, rather than having these people fall in this gap and then needing to create jobs for these folks to walk along with them? Wouldn't it be better to get the money to putting some healthcare facilities up around the state?
Representative Edelson.
Oh, I know that my co-author wants to say words, but I would just say it's both. It's yes and. But Representative Albright.
Representative Albright.
Madam Chair and Representative Grossel, I think you bring up a very, very valid point. And while treatment and behavioral sciences is important for the benefit of the people that would journey through this, the facilities are very important as well, because you can't have treatment without a treatment center. And so they do go hand in hand, and your remarks are well taken. And I think as we move this bill forward, there will be collateral bills that address the issues that you pointedly bring up that I share as well. And so this is a multi-pronged approach, and the bill that you see before this committee today is foundational in its aspects of how that treatment moves forward. And as we look at the provisions of it, we will identify those issues such as facilities, occupational career pathways, and as well as the process itself coming out of the court system and lending itself to DHS, and having everyone be accountable to make sure that people get the treatment and are accountable for the actions and charges brought against them.
Thank you, Representative Albright. And with that, I don't see any other hands up. Representative Edelson, any closing comments?
No, thank you, Madam Chair. I just thank members for the great questions and discussion today. This is a bipartisan. I want to thank my co-author. We've been working hard, and all of the task force members, that we will continue. I promise committee members we will continue to work on this, and we'll look forward to seeing you back in Judiciary soon.
Right, thank you. And I do think, the discussion today has really highlighted that the current system does not work. And we can continue to just use that current system that doesn't work, or we can try something else. And I think that's what you guys seem to be working on. And I appreciate that. I don't usually let someone go after the closer, but Representative Scott, real quick.
Yeah, Madam Chair, I wanted to let people know that I'm going to be voting no on this bill today because I don't think it's ready for prime time, as they say around here. But I think it's obviously an important issue that I think it's a priority for me as well to get this solved, but this isn't ready yet. So I'll be a no today. Thank you, members.
All right. With that, I will renew my motion that House File 27B25 be referred to the Public Safety Committee. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Vice Chair Moeller,
Aye.
Representative Scott,
No.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
No.
Representative Herr,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
No.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
No.
Representative Novotny excused, Representative Farr,
Or no.
Representative Robbins,
No.
Representative Vang,
Aye.
and Representative Zhang.
Aye.
That is 10 ayes and 6 nays.
Right, the motion prevails and House File 2725 is referred to the Public Safety Committee. Members, and thank you to all the testifiers and folks who are on call. I know a lot of work has gone into this bill at every step of the way. The next on our agenda is House File 3064, a Representative Jordan bill. I will move House File 3064 be laid over for possible inclusion in an omnibus bill. That is what's before us today. Representative Jordan, please tell us about your bill.
Well, thank you, Madam Chair, and thank you, members of the committee, for hearing my bill. This is my first time presenting to your committee, and I wish I could offer you all snacks, but feel free to come by my office to dig through my secret junk drawer later. This morning, I am here to present House File 3064, a bill related to local government data and privacy. This bill changes the definition of a licensing agency to include local government units that issue licenses. This bill idea was brought to me by a constituent and local business owner to protect data submitted to the city of Minneapolis that would be classified if submitted to the state. But since the city issued the license, much of that private data would be made public if an individual submitted a data request. The intention of this bill is to keep data private that should be kept private. This bill is being laid over, and I'm working with others to ensure this bill meets the needs of business owners, cities, and the public. And I welcome your feedback. With that, Madam Chair, I'd like to turn over to Phil Steger to go into more details about this bill, what it does, and why it is necessary.
All right, Phil, if you could introduce yourself for the record and go ahead with your testimony.
Thank you, Chair Becker-Finn, Representative Jordan, and members of the committee. My name is Phil Steger, and I'm testifying today as a citizen as well as business owner with industry knowledge in support of Representative Jordan's bill, House File 3064. So Minnesota Statute 1341 Subdivision 2A classifies as private data other than names and designated addresses submitted by applicants for licenses that have been collected, created, or maintained by a licensing agency. And Subdivision 1 defines licensing agency as any board, department, or agency of this state which is given the statutory authority to issue professional or other types of licenses. Representative Jordan's bill would simply create parity between license application data submitted by private citizens to a state agency and the same, and sometimes even more sensitive and private data submitted to a local or government and other government entity administering licenses under state authority. The legislature recognized the vulnerability to invasion and exploitation of private citizens submitting sensitive information to government state agencies as part of an application for a license, simply to be able to do business, carry out a profession, and pursue some economic security for themselves and their families. And so they made that data private. However, times have changed, and local governments may and sometimes do, in some cases, require private citizens to disclose highly sensitive and personal information so that regulators may do the fact finding they need to do to determine whether the license is warranted and in the public interest. And that's a good thing. They should be able to do that. But however, and in so those cases, sometimes the private citizens must submit information or lose the opportunity to attain or maintain the licenses they need to have in order to go about their business. And meanwhile, the world of financial crimes has grown in reach and sophistication. Identity theft wasn't even a thing, I don't think, when Minnesota Statute 1341 was enacted. And stalking, harassment, and other sorts of victimizations of private individuals have unfortunately, in some cases, grown in prevalence too. So under current law, a person with criminal intent, including a member of a criminal organization specializing in identity theft, would have a right to request sensitive personal and financial information submitted by a private citizen to a city agency in pursuant to a license, and the city would be legally compelled to provide it to them, no questions asked with respect to that intent, simply because it is public data, because it was given to a city agency as opposed to a state agency. Minnesota 1341 and House File 3064 would fix that. And it would fix that not by expanding the scope of the type of data that is private or public. We're not creating a new category of private data, but simply by making every government agency, local or state, requiring citizens to submit vulnerable personal financial information in pursuit of a license. It would simply require every government agency to treat this private data the same way as private. Thank you.
Thank you for your testimony. I do have another testifier on the list, Matt Elling. If you could introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair. There we go. I'm sorry to have the video off. Matt Ealing, Minnesota Coalition on Government Information. Thank you for the opportunity to testify this morning. We just wanted to go on the record to express our interest in this bill and to say that we've been in contact with Representative Jordan and we would like to continue conversations about how to narrowly tailor the scope of this bill. What's interesting about 1341 is that 1341 was written to apply to state boards that provide professional licensing for individuals who are seeking certain professional credentials. So lawyers, doctors, police, et cetera. And within that context, there's a pretty routinized methodology for how data is requested and processed, how complaints are handled, and so forth. So that's been in statute since 1981. At a local level, licensing in municipalities really applies to a much, much broader scale of activities. So it could be pet care licensing, if you wanted to get a license to do a pet care business in your home. The placement of public benches in alleys in St. Paul requires a license in certain municipalities. If you want to have a display of antiques, that requires a license. So it's kind of different activities that would fall under 1341. And so what we'd like to do is try to figure out what are the impacts on public data that could happen if you move all of that municipal licensing under 1341. One example is, for instance, in 1341 subdivision 4, there is a confidential classification for active investigative data. And again, in the context of professional licensing, it's pretty clear what that time frame would be and what it would apply to. But in the context of all of this other varied information and activity at a municipal level, it's not really clear how that applies, and it would give cities a greater ability to withhold information that is now public. So those are some of the things we want to examine and try to find a tailored way to address the concerns, the very legitimate concerns that Representative Jordan is bringing forward about financial information, tax returns, those sorts of that sort of data that's submitted at a municipal level in some instances. So we're absolutely happy to keep this conversation going forward and would like to be a resource for this.
Yeah, thank you. And I think one of the things talking to Representative Jordan over the last couple of days, the Chapter 13 is a new and sometimes overwhelming chapter of statute for a lot of folks. So I do appreciate Mr. Elling lending your expertise to folks in this area for sure. Representative Scott.
Thank you, Madam Chair. And Representative Jordan, thank you so much for reaching out on this bill to me. And I think there's a solution here. And I love it when a constituent swerves into something like this. I know it's frustrating for them, but it helps us do our jobs better. And this is, this needs to be fixed because this information should not be in the public realm. So I will just say, as I did in our email exchanges, that I'm more than happy to work with you and Koji on this and come up with the right solution so this kind of data is protected.
Thank you, Representative Scott. I think there's consensus that we need to do something. It's just figuring out exactly how to wordsmith that so we're not having any unintended consequences. Members, any further discussion to House File 3064? All right, closing comments, Representative Jordan.
Yes, thank you, Madam Chair, and thank you, Representative Scott. It's been so helpful to talk to you about this bill, and I agree so much about what you just said, that this is the kind of bill that it's our job to work on, where a constituent brings us a problem. We might not know the answer to that problem, but it's our job to figure it out. And so I'm really grateful to everyone on this committee who is helping me figure out the solution to this problem. And I'm also grateful to Phil and Matt for their help to figure out this problem as well. So thank you for your consideration and all your help this morning.
All right. Thank you. With that, House File 3064 is laid over for possible inclusion in an omnibus bill or further action once folks have worked on this longer. So 3064 is laid over. Thank you, Representative Jordan. We'll move to the last bill on our agenda today, which is House File 803. I will move that House File 803 be referred to the General Register and turn it over to Representative Sundin, Chair Sundin, to present your bill.
Good morning, Chair Becker-Finn, members. Glad to be here this morning. The goal of House File 803 is to bring basic fairness to the Minnesota construction contracts. It's a common sense bill, and it helps small businesses across the state. 803 does three things. Firstly, it ensures that each party is responsible for their own actions and lawyers' fees. Secondly, it aligns Minnesota practice with the American rule. And thirdly, it creates parity on public and private construction contracts by requiring public projects to follow the same principles of fairness we expect from everyone. The bill has the support of 19 trade associations, and I have 3 testifiers today to help us understand the bill. They can introduce themselves in order, but first up would be Jason Tarasek.
All right, Mr. Tarasek, please introduce yourself for the record. And we've got several testifiers signed up, so we got to keep things to about two to 3 minutes if you can. Mr. Tarasek, please go ahead.
I'll do my best. Thank you, Chair Becker-Finn and committee members. My name is Jason Tarasek. I am an attorney in private practice with the Tarasek Law Office. I have practiced construction law for more than 20 years, and it's been my honor for the last several years to serve as the chapter attorney for the Minnesota Subcontractors Association. Thank you for hearing this important bill, and I hope you pass it today. Minnesota subcontractors need this bill because of the monumental power imbalance between subcontractors and general contractors. This imbalance in bargaining power is why it's so important that you ensure a basic level of fairness in the construction industry. Public policy should not allow a contract to pass risk onto a small business when there is absolutely no connection to the subcontractor's work, much less any fault on behalf of the subcontractor. Before I walk you through this proposed legislation, I'll provide a little history on the recent changes to the laws in this area. In 2013, the legislature amended the anti-indemnity statute to make it clear that indemnity agreements and construction contracts could only hold contractors responsible to the extent of their own fault. This may seem obvious, but it had to be statutorily required because subcontractors were being required to pay for damages, monetary damages, even when they were not negligent, and the judgments rendered were against someone else. Since you changed that law in 2013, attorneys have circumvented the anti-indemnity law by imposing obligations upon subcontractors to defend them against claims for which the subcontractors had no connection, much less any fault. I believe you have an excerpt from one of those recently divided contracts among your materials today. Through this new tactic, general contractors now force subcontractors to pay the general contractor's attorney's fees throughout a dispute, amounts that often exceed the actual damages and could put the subcontractor out of business. Just to be clear, as the law is written right now, a subcontractor can be contractually required to defend a general contractor and pay the general contractor's lawyer's fees, even when the general contractor is solely negligent. That doesn't make any sense. That's unfair. Through this tactic, the general contractors pass all risk onto the subcontractors. This bill is similar to other legislation already on the books here in Minnesota. For example, the trucker statute, Minnesota statute section 221.87, I'll repeat that, Minnesota statute section 221.87 prohibits similar such practices. Indeed, more than 40 other states have laws prohibiting similar risk transfers. House File 803 is similar to laws in Iowa, Oklahoma, Colorado, and Montana, and others. In passing its law in 2007, the Colorado legislature said, and I'll quote, "If all businesses, large and small, are responsible for their own actions, then construction companies will be able to obtain adequate insurance, the quality of construction will be improved, and workplace safety will be enhanced," end quote. Every day in Minnesota, subcontractors are being asked to make the horrible choice of either signing a ridiculously unfair contract or simply foregoing the work. In my experience, when asked, general contractors rarely remove these provisions. In short, these terms are essentially non-negotiable. Unless you pass this law, subcontractors will continue to suffer the onerous contract terms that potentially expose them to massive financial obligations through no fault of their own. I just have a little more. Thank you for bearing with me. These contract terms significantly also hurt DBEs, disadvantaged businesses owned and operated by women, minorities, and our veterans who are struggling to enter the construction industry. Indeed, in the 2017 Minnesota Joint Disparity Study on the Minnesota Department of Administration, it included the following quote: "Public sector insurance requirements are a barrier to businesses seeking public sector prime contracts and subcontracts." One business owner said, for example, "You have to pay the insurance premiums that exceed the limits of a normal policy, and it takes away from our profitability." I believe one of the next testifiers will talk about how this impedes her business. So with that history in mind, let me briefly run you through what this bill will do. First, starting at section 3, line 2.22, the bill adds the word defend to the definition of indemnification agreement in Minnesota statute chapter 337.01, which is often referred to as the private construction statute. Adding the word defend to the definition of indemnification agreement will close the loophole in the anti-indemnity statute that still allows a negligent general contractor to force an innocent subcontractor to pay the general's attorney's fees. Next, in section 5, line 3.3, the term project-specific insurance is deleted, which removes ambiguous wording that some general contractors have used to get around the anti-indemnity statute. If you'd like an article explaining that, I'm happy to send it to you. It's kind of complicated, I admit it. Lastly, sections 1 and 2 create parity between the public and private projects by ensuring the private construction statute in section 337 matches the public construction statutes found in sections 15.71 and 15.72. Okay, big finish. In closing, Representative Sundin's bill would promote basic fairness for all construction businesses. Subcontractors are not trying to get out of being responsible for their own actions or their own legal fees. They just don't want to be forced to pay the general contractor's legal fees when the general contractor is the only one at fault. This is not a dramatic change. It only ensures a reasonable measure of fairness for subcontracts. 19 organizations and trade organizations support this bill. Please vote today for House File 803. I'm happy to stick around for questions. Thank you for your time. I'm sorry if I took more of it than I promised.
You did, but you were doing some of the walkthrough, so I gave you some of Representative Sundin's minutes.
Thank you,
next on the list, I have Tamara Sunby. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair and committee members. My name is Tamara Sunby, and I'm the proud owner of GTS HVAC. We are a woman-owned DBE HVAC company. We've been in business for 16 years and have 3 trucks in the field. We've made it through the pandemic, and I hope to stay in business for another 16 years. Well, one day I hope to hand my business down to my sons or daughters. But many of the contracts that we're being asked to sign may put us out of business in a blink of an eye for someone else's mistakes. The defense demands that some general contractors and public owners are requiring they put my business on the hook for their actions and their legal fees. It's not fair, it's not right, and it's got to be fixed now. Why should I have to pay to insure someone else's mistakes, especially someone who I have no authority over? Seriously, I ask myself, how is this even legal in Minnesota? Public owners are begging small women-owned, minority-owned DBE businesses like myself to come on board for these public projects. Yet, they're expecting us to sign these unfair contracts. I have had to turn down a number of jobs or potential job opportunities because of non-negotiable defense provisions. It's impacting the growth of my business. I've also had to hire attorneys in advance to argue terms before I even get the job, which means I am paying for a project I may not even get. If I do happen to get the job and I get up on the job site, I am already needing to perform perfectly as to make money. As I speak, GTS is currently having to make a decision not to pursue a $32,000 payment that was promised on a public project due to these very legal fees. I know many of my peers are signing these contracts so that they can get work. Many of them don't even understand the risk they're putting themselves at. Or even worse, they're being bullied and shamed into signing them. I'm testifying today because I want to help this unfair practice end for myself and others. It's a little daunting, but I'm proud to be testifying on behalf of other women business owners and with another woman business owner today and stick up for our industry, even if no one else will. I'm just asking members to please pass House File 803 today and bring some common sense back to Minnesota contracts. And I'll stick around for questions if there are any. Thank you.
Thank you very much for your testimony. You did a great job. Next, I have Palita LaPlante. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Chair Becker-Finn and members of the committee. Thank you, Jason, and thank you to Tamara. My name is Palita LaPlante. I'm the majority owner of Prescription Landscape. And as Tamara noted, we are also a certified woman-owned business. Incorporated in 1980, our company is one of the largest landscape companies in the state. We're a full-service provider of land care, snow, ice, and construction services. We have branch facilities in St. Paul, Shakopee, Crystal, and St. Cloud. We frequently subcontract work to small businesses, DBE, MBE, and WBEs. Our size, however, does not matter when it comes to doing construction business, considering the current provisions of contracts related to indemnification agreements. Our construction division is much smaller in comparison to the rest of our business because my partner and I are unwilling to risk bidding on extremely large products wherein the indemnification clause is onerous. When I say large, I am not referring to the landscape and irrigation value, but the overall project value. The practical effect of certain contractors' indemnification language is to shift the entire risk of loss to us for an indeterminate universe of claims. We are cautious when there is no clarification of type of claims, especially when one sees the words all claims in the indemnification clause. This can be read to include claims where there is a thin or even no nexus between the claim and our work activity on the job site. The definition of work itself can be an issue, since one needs to be certain that work means our work and does not encompass all work on a job site. We therefore need to be careful to understand the extent of coverage that is potentially being requested and the money actually at risk. There were a few occasions where we agreed with our insurance carrier to increase our coverage for certain projects, but no more. The risk outweighs the benefits. We will continue to be conservative and turn business away and its attendant risk. Laws should not force businesses to gamble on the risk of another business failing to perform their work safely or competently. For that reason, I respectfully ask that you support House File 803. Thank you so much.
Thank you for your testimony. Next on the list, I have Connie Armstrong. Please introduce yourself for the record and go ahead with your testimony.
Good morning, Madam Chair, members of the committee. My name is Connie Armstrong. I'm senior counsel with McGough Construction Company. We are a 6th-generation, family-owned commercial union general contractor headquartered in Roseville, Minnesota, and I'm testifying today on behalf of the Association of General Contractors. At McGough, I'm responsible for contract negotiations, insurance procurement, and claims management. I also serve on the AGC's contract committee. I'm here today testifying in opposition. I would like to state that if this bill accomplishes what the proponents actually represent, there would not be a need for my testimony here today. We have two concerns primarily with House File number 803. The first concern is the addition of the word defend in Section 4, Subdivision 3. The proponent's stated objective, one of the proponent's stated objectives today is preventing a small subcontractor from having to defend the action of others, which a bill we would support if that such language was added. We have actually been in good faith negotiations with the MSA, yet despite the changes necessary to accomplish their stated objectives, this is not reflected in the current bill and it does not address the concerns that we have voiced. Contrary to their stated objective, this addition can have the opposite effect and will actually shift the defense responsibility from an at-fault party and its insurers to a faultless party that contracted with them. By way of explaining a little bit more, under Minnesota law, an upstream contractor is vicariously liable for the acts and omissions of the downstream contractors, subcontractors, regardless of whether or not the contractor even performed any construction work on a project. Minnesota rules do not require that a plaintiff who sues an entity who performed the actual faulty work. Instead, the contractor is sued directly because of its vicarious liability rather than a subcontractor who performed the work alleged to be faulty. The problem here, though, is fault is not determined at this early stage of litigation, and defense responsibility should lie with the entity who performed the work that is the subject of the allegations. This is the reason that the industry has established the system that it has. For one, it allows an upstream contractor to seek defense from the downstream subcontractors and their insurers, whose work is allegedly faulty. These are the parties who will benefit from the defense that's being asked. Two, the system also allocates indemnification responsibility for damages to the parties determined to be at fault for those damages. This is a fair allocation and is consistent with how the insurance provides coverage for both defense and indemnification. To be clear, we agree that uninvolved subcontractors whose work is not alleged to be faulty should not be required to provide defense in circumstances where there are no claims arising out of their work. They do not benefit from defense and aren't at fault for damages. We are not aware of any cases, nor have the proponents been able to demonstrate any situation where an upstream contractor has forced a downstream subcontractor to pay for a contractor's defense costs without a nexus to the subcontractor's scope of work or because of the contractor's negligence. The other concern that we have with House File 803 is the removal of the project-specific insurance as an allowable form of insurance. And this is in Section 5, Subdivision 1C. It's unclear really why there's a need to disallow project-specific insurance. These insurance products benefit all parties on a project. This will be a huge change to the construction insurance industry and will affect every construction project. The parties who benefit the most from project-specific policies are the small disadvantaged companies, since the policies put them on equal playing field with all the large competitors. Instead, removing this insurance harms smaller contractors who may not be able to procure the insurance to manage risk and to protect themselves. And this is contrary to what the proponent's stated goals is. For these reasons, we have
Ms. Armstrong, I need you to wrap up so we can get to the last testifier.
That was what I was saying. Thank you, Chairman. For these reasons, I just wanted to say these are the concerns that we have about the bill, and I will also stick around if there's any questions that I'm able to answer.
All right, thank you. Last, I have Jim County. Please introduce yourself for the record and go ahead with your testimony.
Good morning, Madam Chair and members. My name is Jim County. I'm with MnDOT, where I'm Deputy Chief Counsel for Construction and Contract Management, and I'm speaking also on behalf of the Department of Administration this morning. You've heard from subcontractors, you've heard from a general contractor. I'm going to bring in a little different perspective, which is from the public project owner's perspective, and some concerns we have about the bill in its present shape. So there's I think kind of a common expression in the construction and insurance industry that the duty to defend is broader than the duty to indemnify. In other words, an insurance company must defend an insured against claims that are arguably within coverage, where the insurance company only has to indemnify those claims that are actually within coverage. And what this bill before you does is it conflates the duty to defend with the duty to indemnify. And it seems kind of simplistically to be a fairness issue, but it's a little more complex than that. And this bill, I think, causes some unintended consequences for public project owners, and it's problematic that it conflates those two duties. First, this change sort of puts the cart before the horse and kind of seems to require a determination of liability before a duty to defend kicks in. And it's unclear how this works. And this is, in my opinion, kind of at odds with Minnesota's system of notice pleading, where you can have cases against defendants or even multiple defendants as long as you have at least some facts indicating that a party might be responsible. And then you use the discovery process to, determine who's really at fault and kind of winnow out those who aren't really at fault. Here's an admittedly simplistic example. A hammer falls off a roof and injures a person standing below. I probably don't know right away if that hammer belonged to the general contractor, to the roofing subcontractor, to the HVAC subcontractor. So I'm probably going to bring them all into a lawsuit, knowing that the discovery process will sort of ultimately result in the truth of whose hammer that was. Will I bring in the landscaper who was never up on the roof? No, because in my opinion, that likely would not survive a motion to dismiss. Our second concern is we think that project owners will be required to defend more cases that the general contractor should really be defending, as the general contractor apparently would be able to just kind of deny liability and push the owner to prove that the general contractor was negligent. And the owner will have to do this even though the contractor has an insurance policy that will cover the cost of this defense. Now, there are other things the owner could probably do, like bringing in the contractor as a third-party defendant, but this all means more complex litigation and more costly litigation in the construction industry. And of course, the money that public owners spend on litigation means less money available for bridges, buildings, curling rinks, and other public improvements. So the public owners are very concerned about this, and there are other public owners I know who share my concerns who are unable to be here today. I'd like to, in summary, closing, I'd like to thank Chair Sundin for bringing this important issue forward. And while we as public owners are concerned about the unintended consequences of this bill, we certainly welcome the opportunity to continue to work with Chair Sundin and the proponents on how to best have contract clauses that are fair to all participants in the construction process, including public owners. Thank you, Madam Chair.
All right, thank you for your testimony. And unfortunately, bringing up curling did not earn you points because it just reminded me that Team USA lost. So unfortunate news if folks missed that. That's the end of our testifiers today. Any discussion to the bill, members? Representative Vang.
Thank you, Madam Chair. I just want to thank Representative Sundin for bringing forward this bill. And I also want to thank testifier Tamara, who is also my constituent. I'm happy to hear you speak today and hear your story. And I'm happy to support you and your business. It's not often that we hear directly from our own constituents in committee. So I really appreciate you coming out to share your story. Thank you.
All right, thank you. Brian's iPhone, I'm not sure if you're a member of the committee. I'm going to assume that you are. We'll mute you if you're not. Brian's iPhone. All right. Any other members have questions?
Yeah. Representative Chair
All right.
Becker,
I can tell now that it's Representative Johnson. Representative Johnson, please go ahead.
I was just going to say, I do overall like the concept of this bill. As being involved with some general contractors in building some buildings and also doing work as a subcontractor. The general contractor is the one responsible to make sure the subcontractors are doing the job responsible. They should have people on site making sure the work is being done properly. If there is an issue, they should be talking with the subcontractor to make sure that changes are done. If they're not doing that, the general contractor is not doing their responsibilities. So I do, like I say, I do support this bill.
All right, thank you. With that, Chair Sundin, any closing comments?
Yes, thank you, Madam Chair. I really appreciate your attention today. You know, when construction outfits get involved in lawsuits, it's very troubling for them. It's very expensive, and this bill will bring about a lot of a fair amount of fairness to the process. You know, and then I'd just like to remind people that when you involve so many attorneys in the decision making of the future of a small company, subcontractor, it's just so unfair to them. If one attorney threatens to sue another attorney, you know, that's like threatening a 6-year-old with a candy bar. You know, let's get going. Somebody's going to make money on this one, but the end result when you involve subcontractors, smaller contractors, this could destroy their business. So I just remind you of the American rule brings fairness to all the businesses. And just a quote from the Colorado law that was enacted in 2007, if all businesses, large and small, are responsible for their own actions, then construction companies will be able to obtain adequate insurance, the quality of construction will be improved, and workplace safety will be enhanced. So let's do the right thing and follow the American rule. Nothing more, nothing less. I hope everyone on the committee can support House File 803. Thank you.
All right, thank you, Chair Sundin. And maybe don't talk smack about attorneys when you come to Judiciary.
Point well taken.
With that, I will renew my motion that House File 803 be referred to the General Register. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Representative Moeller,
Aye.
Representative Scott,
Aye.
Representative Weiss,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
Aye.
Representative Hur,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
Aye.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
Aye.
Representative Novotny,
Novotny, aye.
Representative Farr,
Farr, aye.
Representative Robbins,
Aye.
Representative Vang,
Aye.
and Representative Zhang.
Aye.
Okay, that is 17 ayes and no nays.
All right, the motion prevails and House File 803 is on its way to the General Register. Thank you, members, for hanging in an extra 4 minutes. Another productive week in Judiciary Committee. And with that, we are adjourned.